Well, now the defense has filed a reply to the Commonwealth's response to the defendant's motion to dismiss based on double jeopardy. So first we had the defense filed a motion to dismiss based on double jeopardy. The Commonwealth filed a response, which we just did a video on yesterday, breaking that down, talking about some of the important case law. And now the defense filed a reply to the Commonwealth's response. So we're going to be breaking all this down for you. It's important, again, to set the stage. First of all, if you haven't seen those two videos that I dropped about this specific motion and this specific law, you got to go check that out. It will really help you set the stage for what we're going to be discussing today. But nevertheless, we're going to recap briefly what I discussed in which is relevant to the reply that the defense filed in this case. So let's set the stage again. Remember, there was a few different bases to ask the judge to find that there should be double jeopardy here. The first one was the fact that all the jurors have now come out. Well, not all of them, but let's say 4 are reporting that all 12 really agreed 12-0 that Karen Reed should be acquitted of count 1, second-degree murder, and count 3, leaving the scene. And therefore, the only count really that the Commonwealth can choose to retry is count number 2. All right. So first of all, we did discuss whether some of their arguments actually should really double jeopardy attach to the entirety of the case, meaning count 1, count 2, and count 3. Nevertheless, let's just make it simple and assume that they're only asking for count 1 and count 3. Now, the first reason is because now all the jurors really agreed that it's 12-0. That's what we voted. Let's just bring them back to court and let's they'll tell us again what their voting was on count 1 and count 3, and therefore we'll get an acquittal on the record for count 1 and count 3, and then it'll be clear double jeopardy will attach, right? So that we already explained in every single video that we discussed, that argument is going nowhere in a hurry. It's not going to win. The judge is probably not going to give it more than 30 seconds of time to discuss why she's denying that part of the motion. All right. So the defense still did spend the first 4 pages of its reply brief talking about that issue, even though if they were following brother counsel's advice, they wouldn't have wasted that much time because that's going nowhere. But the other part is actually more interesting, which we've discussed already in the past 2 videos, and we'll just briefly catch you up to speed on what the other part, which is a little bit more meritorious, why there should be double jeopardy. And that's for the simple reason that if a mistrial is declared and it was inappropriate for the judge to declare a mistrial, then double jeopardy can also attach. Okay, so again, if the mistrial was proper, then of course the Commonwealth can bring the case again. If the mistrial was improper, then they cannot bring the case again. Double jeopardy would attach. How can a mistrial be declared and it will be proper, and how would a mistrial be declared that'll be improper? So if the defendant requested for a mistrial, then obviously it's appropriate, and that's fine. If the defendant consented to the mistrial, that would also be an appropriate mistrial. Now, we spoke about, was there any request by the defense for a mistrial? And we explained very clearly, no, there was no request by the defense. They never asked for a mistrial. Yes, they asked for a Tui Rodriguez charge, but they didn't ask for a mistrial. And therefore, that part is certainly that the defense did not request it. What about consenting? Did they consent? And this is where we spent a lot of time on yesterday's video about the argument that the defense made in their motion that even when a defendant or defense counsel does not object to the mistrial, that's not considered consent. That's what the defense's position was. And they brought a case called Commonwealth versus Edwards to support their argument that just by the fact that they did not object does not mean that they consented. And then we explained in yesterday's video why their reliance on Commonwealth versus Edwards is misplaced. It's actually taking the opinion completely out of context. If you understand the opinion, if you read that opinion, then the opinion actually stands for the exact opposite, which is why if I was the Commonwealth, if I was the prosecutor, I would quote that exact case and bring the full context of that and point out how the defense quoted that case as standing for an opposition for the proposition, which is that failing to object means that you did not consent. And really, the opinion stands for exactly the opposite. By failing to object, that is consent. And that's exactly what the opinion says. You just have to read the whole opinion. And if you understand it, that's what the opinion's saying. So the Commonwealth did not quote that case because they didn't ask my opinion. So they did bring other cases also, which very clearly show that by failing to object, that is consent. So now let's ask ourselves this question over here. By the fact that Alan Jackson or David Yannetti or Elizabeth Little did not object to the mistrial, does that mean that they consented? And if that's what it means, then there's nothing more to analyze. Let's understand that, because we don't even move on to manifest necessity unless you can show that there's no request and that there was no consent. Then you move on to manifest necessity. But if you can show and you can argue that there was consent, then there's nothing else to talk about. So there's no question that by failing to object, the case law is clear that there's something called implied consent. And that would mean that you implied consent by failing to object. That's clear. The question now becomes, well, let's say we didn't have the opportunity to object. You're right. We should have objected if we had the opportunity. And if by failing to object, that would mean consent. But here we didn't have the opportunity even to object. And therefore, since we didn't have the opportunity to object, you can't read into our failure to object as us consenting. So for this, the defense quoted a case called Commonwealth versus Horrigan. And in Commonwealth versus Horrigan, they cited, and this is what they said in their papers, they said that since this action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel, then they cannot take the fact that they were silent and failing to object as consent, because the action was sudden, brief, and unexpected. Right? The judge just came in and read the note and then quickly said, I'm declaring a mistrial, go back to the jury room. So that's sudden, that's brief. So the case in Horrigan, this is what they're quoting. They're quoting this Commonwealth versus Horrigan shows that when it's sudden, brief, and unexpected, then the fact that the defense counsel is silent does not mean that he failed to object, because he wasn't really given the opportunity to object. So let's talk about this case, because it's a very important case. Because once the defense can prove that, or they can argue and they can say that this is how the law comes down, that we did not request and we did not consent, then they can move on to the next argument, is whether this was manifest necessity, and they can argue that there was no manifest necessity either. Right? Okay. So actually, if you look up the case Commonwealth versus Horrigan, it's not as simple as the defense makes it. All right. So here's another case, not just Commonwealth versus Edwards, but now we have Commonwealth versus Horrigan, which also is not as clear as the defense likes it to be. And this is what happened in Commonwealth versus Horrigan. What happened in that case was that they had one day of trial. The next day of trial, the trial judge was not able to come. He had a family emergency. So they're all waiting in the courtroom. The judge doesn't show up. A different judge shows up, the first justice of that courthouse, and that first justice walks into the courtroom, tells the jury, I'm sorry, the judge had a family emergency where I am required to order a mistrial, and therefore you can all go home. That's it, without any input from the defense, without any discussion with the defense or the prosecutor, just gets up there and says, I'm declaring a mistrial. Well, when they tried to bring the case again, what do you think the defense did? They filed a motion for dismissal based on double jeopardy, because this was a mistrial without their consent, and there was no manifest necessity, all the other arguments that they made. But really the main issue that we have to talk about was whether this considered consent. Now, the Commonwealth's position in Commonwealth versus Horrigan was that the defense did have the opportunity to object when the judge was talking. When the judge was talking to the jury and saying that I'm going to have to order a mistrial in this case, at that juncture, the defense could have made an objection. So let's listen to what the opinion holds. The Commonwealth argues that even if manifest necessity did not exist, so let's assume the manifest necessity, this is again the Commonwealth arguing, and let's say even if manifest necessity did not exist, and if it did not exist, then that would certainly be a reason that this mistrial was inappropriate. So the Commonwealth says, no, even if there's no manifest necessity, the defendant's constitutional claim should still fail because his counsel consented to the mistrial by not registering an objection at the time. The Commonwealth points to the moments during which the first justice spoke, more particularly perhaps the interval between the speaker's third paragraph and the end of his statement. So it was a whole long statement that he gave, that the judge gave. And during that statement, the Commonwealth points out that there are certain times that the defense could have objected, as time in which the defendant could have considered and then uttered an objection. So this is what the opinion holds about that. This underestimates or ignores the difficulty of reaching a decision whether the defense would be advantaged or the opposite by a second trial. The possibilities ahead cannot be instantly calculated. This happened, was a surprise to everybody. It was a surprise to the defense counsel. He's sitting at the trial getting ready for day 2 of trial. All of a sudden, a judge walks in, who's not the sitting trial judge, and starts saying how there's going to be a mistrial. So you want him right away. Now, trial attorneys always have to think on their feet, but this is a little bit much. All of a sudden, this judge is getting up there and ordering a mistrial. And he's supposed to right away think about everything that's going on, quickly remember all of the case law about it, and that he has to object, and that he actually does object within that few seconds of time. So therefore, this court, the opinion held, this case, Commonwealth versus Horgan, that you can't expect that out of him. It was just too quickly. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise. So we can't expect trial attorneys, even trial attorneys, to think that quickly on their feet. That much they can't. And it's not done yet. So if we would just stop it there, then the defense can certainly make a strong argument. Look, this is just quick. It was abrupt. It was unexpected. The same way what happened in this case. The judge didn't even give us a clue about what the note said and that what action she's about to take by declaring a mistrial. So this was a surprise, just like Commonwealth versus Horgan. And therefore, by the fact that the defense, Alan Jackson, David Nettie, did not object, that shouldn't hurt us, and that shouldn't be construed as consent. But you have to read a little bit further, like in a lot of these opinions. Now listen to this. And an examination of the decisions shows that where silence in the face of a declaration of mistrial has been held to indicate consent, the total situation was such that the defendant could reasonably have anticipated that the issue of a mistrial would arise and could prepare himself for the event. Silence could then be plausibly read as acquiescence. So what is the opinion saying here? Well, the opinion is saying here, look, if a defendant or a defense counsel could reasonably anticipate that the issue of a mistrial would arise, then I'm not saying that silence is not to be considered as consent. So meaning silence then could be construed as consent. So if the defense had a reasonable anticipation that we can be heading down towards a mistrial, and then they're still silent, well, then that could be considered consent. So it's not exactly as how the defense quotes this case, Commonwealth versus Horgan, to stand for the proposition that anytime it's unexpected, when the judge just walks into the room and reads it and says we're going to declare a mistrial, and you're silent, not in every single situation is the ruling that it's not considered consent. So in this situation, you have to ask yourself, well, in this situation, could Yannetti and Alan Jackson have anticipated or reasonably anticipated that we're going down mistrial land? Of course they could have, right? Of course. They're sitting in jury deliberations for 25 hours. They've already gotten 2 notes saying that they're hung. So therefore, this case actually doesn't really help the defense. And again, it could be quoted by the Commonwealth as support for their argument that in this specific situation where Yannetti and Jackson, both seasoned attorneys, see a mistrial coming down the road, which they should have thought about whether they want a mistrial or object to a mistrial. They should have already thought about it. And therefore, by the fact that they're silent, even though it was quick and unexpected, that the judge just read the note and said, I'm going to declare a mistrial, right then they could have already anticipated, if she does this, I'm going to get up and object. And they didn't. So that's an argument that could be made back by the Commonwealth with respect to this specific case. But let's continue down the road. Let's just play devil's advocate for a minute and say, okay, even in this case, you can argue that here really there was so little time. It wasn't like in Commonwealth versus Horrigan, there was a whole long statement that the judge read to the jury. You can take a look at it in this case, in the opinion. In this case, in the Karen Reed case, the judge read the note, said, I'm not going to do that. I'm declaring a mistrial. You literally had about 2.5 seconds to react to that. Now, yes, maybe you can argue that Yannetti and Jackson should have anticipated that we may be faced with a mistrial. What are we going to do in that situation? And therefore, as soon as those words come out, they should have been prepared and ready to do that. But you can also make the argument that because it was so fast, it was literally 2.5 seconds. There wasn't like a whole statement, a whole long thing where they can actually just get their bearings together about what's actually happening right now. So maybe you can still make the argument that there was not an opportunity, not a fair opportunity for them to be able to lodge an objection to the mistrial. So let's just assume that that argument actually has merit. Okay, so let's assume that that argument has merit. They didn't really have a good opportunity to object, and therefore we can move on to the area of manifest necessity. All right, so let's go into the reply now. I'm just going to read certain parts of it that have to do with this next prong, because again, like we said, you can't move on to manifest necessity if you find that the defense either requested or consented to a mistrial. If they requested or consented to a mistrial, you can just ignore manifest necessity. So therefore, this whole issue about whether them being silent is consenting is a very important issue, and you don't conflate it with the prong of manifest necessity, which, by the way, I think that the defense is a little bit guilty of conflating these two when you're reading their papers. But let's continue. So this is what they argue. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. So this is the page 4 already, because we skipped the first 4 pages, which have to do with the jury coming all to the defense attorney and saying that really we voted not guilty, which I already explained is going nowhere in a hurry. All right. So the lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute a manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of a mistrial with respect to all counts. Contrary to the Commonwealth's characterization as unambiguous, meaning the Commonwealth said that the note that the jury sent to the judge, which said that they're deadlocked essentially on all charges, right? The Commonwealth said that's unambiguous. It's clear what they meant. They meant that they're hung on all of the charges, all of the counts, count 1, 2, and 3. So this is the defense's best argument that really, when they wrote all charges, they didn't really mean all the charges. The jury note at issue here was facially susceptible to 2 alternative interpretations: that the jury had reached an impasse as to all charges, which is what the Commonwealth understood, or 2, that the deadlock applied to only some of those charges on multiple lesser included allegations within a single count, such as count 2. So they're trying to argue, and this is what they argued in their motion also, that when the jury note said that they're hung on all charges, it could be understood as all charges in count 2, which I think it doesn't take a rocket scientist to understand that that's a real stretch. Okay, the actual language of the note says that they're hung on all charges. Well, all charges usually means all charges, not just all the charges in one of the counts. So it's not a great argument. It's just not. All right, but they still make it anyway. Now, they also talk about the fact that the Commonwealth argued that really the judge should not ask the jury for separate verdicts on count 1 and count 2 and count 3, meaning continue asking the jury, well, are you hung on count 1 and count 2 and count 3, or are you hung on only one count? Don't even make that inquiry. And they cited a number of cases, which we really spoke about in the last video. And just to point out that the defense here made the same argument that I did in my last video, that the fact that all of those cases we're talking, all the cases where the Commonwealth quoted, which stood for the conclusion that the judge should not make an inquiry into separate verdicts, that's only when it's talking about a charge of lesser included. when you have one charge and you have a bunch of lesser included in that one charge. So then the judge shouldn't ask them for separate verdicts. So that this would be like in this situation, if on count 2 they were hung and they said we're just hung on count 2, and start asking them, well, which part of the lesser included? Can you agree to any of the lesser included? That's what all the cases say, but not when there's 3 completely separate counts. There's no problem at all. In fact, it's straight out a Massachusetts Rule of Criminal Procedure 27B, which says that the judge is allowed to do that when you have 3 completely separate counts, which happened in this case. So they did point that out as well. All right, so let's move on to the next argument by the defense, their reply. The Commonwealth's attempt to shift blame to the defense overlooks the black letter rule that the prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. The defense's request for a Tui-Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts. So now they're taking care of this argument some people have been making by the fact that the defense requested a Tui-Rodriguez charge. Well, that should somehow mean that the defense agreed that they're deadlocked on all the charges, or that they're agreeing to a mistrial, which they obviously point out that, like I did in my last video, that's not what it's doing at all. When you request a Tui-Rodriguez charge, that's not what you're doing. So they're just making this argument. The defense's request for a Tui-Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts, nor did it commit the defense to any position regarding whether the court should sua sponte declare a mistrial. So it's not taking any position about whether the court should go and declare a mistrial. A discussion with counsel, such as that occurring twice earlier in response to jury notes, and either the consent of the defendant to a mistrial or further judicial inquiry of the jury instead, was required. So they're saying, again, like we know, which is also straight out case law, that the appropriate way, the regular way to do this is by showing the note first to the attorneys before you bring in the jury, which was not done in this case. So they're just pointing that out. It is indisputable that the court provided no opportunity for defense counsel to be heard regarding the declaration of a mistrial, as opposed to the appropriateness of a Tui-Rodriguez instruction. In short, mere silence absent an opportunity to object does not amount to consent. And here they refer to their case law, which they cited in their motion, which we already discussed, which was Commonwealth versus Horrigan. But we're also going to move on to some of the other cases that they quote with respect to this prong of not being able to make a record, which again, we shouldn't confuse. We shouldn't confuse manifest necessity with consent. Okay. When it comes to manifest necessity, the case law said that you have to have 2 things. Number 1 is that the judge has to give counsel full opportunity to be heard. That's the first thing under manifest necessity. And number 2 is that there has to be careful consideration for any alternatives. Those are the 2 requirements if the judge wants to find that she has to order a mistrial or declare a mistrial because of manifest necessity. But again, we don't analyze those 2 prongs under consent. You can't conflate the 2, which what they do a little bit in this reply. But anyway, let's continue. So the other 2 cases here, which they quote in their brief, and this is in their first motion, was Picard versus Commonwealth. Now, Picard versus Commonwealth, what happened here is that the defense attorney, was asking inappropriate questions. He wasn't allowed to go into a certain topic. And as soon as he went into the topic, it was about a civil lawsuit. As soon as he went into that topic, this is Picard versus Commonwealth. As soon as he went to that topic, the judge stopped him. Well, the prosecutor objected, and the judge said, "Stop! You're not allowed to go into that area." And then this attorney did it again, right in front of the judge's face. As soon as they had this discussion, and then the judge said the following: "Do you want me to call a mistrial because of your conduct?" Meaning the defense attorney is completely ignoring the judge and continuing with the questions about this civil lawsuit. And it's a criminal trial. And the judge ruled that that's irrelevant. And he continues to do it. So the judge says, "Do you want me to order a mistrial because of your conduct?" And the defense attorney said, "No." Now, there's a footnote there that the footnote says, and this is important, that the court treated that like an objection. Okay, so now if I'd ask you, should we analyze this case, Picard versus Commonwealth, under whether there was an opportunity to make an objection? No, because the court recognized the defense attorney saying no as his objection to the mistrial. So an objection was clearly made. So really, this case has to do with manifest necessity. So what the court found was the following: no opportunity was given counsel to argue the propriety of the question or of the necessity of a mistrial. So it wasn't there wasn't a fair opportunity given to the defense counsel in that case to argue against the mistrial. We must conclude that the judge responded without meaningful consideration of alternatives. Thus, no manifest necessity for a mistrial was shown. So that's that. This case ended up in a mistrial, and the record showed that there was no opportunity really, other than that quick, do you want me to order a mistrial? No. And then the judge just ordered a mistrial. So there was no opportunity for the defense counsel to respond, to consider, for the judge to consider other alternatives, or whether a mistrial is even necessary. So therefore, this opinion held, Picard versus Commonwealth, this case held that there's no manifest necessity because there was no opportunity for the defense to make a record, and there was no meaningful consideration of alternatives. Okay, now it doesn't say that there has to actually be alternatives that the judge is going to follow. It just has to be that there has to be meaningful consideration of those alternatives. And we're going to see why that becomes a big problem at the end of this analysis. So that is one case. Again, once you move on, if you get past the consent issue and you say that over here there just simply wasn't enough time, there wasn't any opportunity to make an objection, and that therefore we cannot construe the silence as consent. Now we move on to manifest necessity. Well, in this case, in the Karen Reed case, was there any sort of meaningful consideration of alternative to a mistrial? And was there any opportunity for the defense to be fully heard on anything about the mistrial? No. So once you get to manifest necessity, the defense here has a much stronger argument. Let's continue. There's one more case before we get to the very, very important case, which we mentioned in yesterday's video. And we're going to see how the defense discusses or distinguishes this specific case. But first, we'll go to Commonwealth versus Stewart. Commonwealth versus Stewart, what happened in that case was they initially had a jury of 14, and then the next day for trial, only 11 showed up. And the defense, again, did object to any sort of mistrial, and even suggested a solution that they should adjourn or continue the case a little bit later, give a day off, see what happens. Maybe we can get some jury back. Maybe they'll feel better. And also the defense said will consent to allowing this jury of 11, a panel of 11, to decide the case. So there's a number of different suggestions that were made, and the defense objected in that case. But the judge ordered a mistrial anyway. Now, the reason why this is so interesting is that here there was actually some discussion about alternatives on the record. So you could make the argument that there was some meaningful consideration or careful consideration by the judge for alternatives. And this is what the court held in that case, which is amazing. It's really interesting. Again, Commonwealth versus Stewart. And this is what the court held. Regrettably, the trial judge in this case first ruled that he was going to declare a mistrial, and then, almost as an afterthought, unenthusiastically asked whether counsel objected. So here, really, he didn't ask if there's an objection. He just did it unenthusiastically. And that itself showed is playing a big role here. The sole indication that he considered the alternative of a continuance was his comment that the flu season has strung us with a vengeance. So he actually did consider an alternative, albeit unenthusiastically. Is that going to be enough, or does it have to be much more careful consideration? He might have directed an officer to call the homes of the missing jurors for a report of their conditions. The juror who was absent because of a death might have appeared on the following morning. A continuance of one day was warranted by these circumstances. Alternatively, he should have inquired whether the defendant was willing to sign the appropriate waiver and continue with 11 jurors. He did neither. So even though he technically did consider some alternatives and rejected them, that wasn't enough. That wasn't careful consideration enough, according to the court. And this is a Supreme Court case in Massachusetts. So we have two. Picard was also a Massachusetts Supreme Court case, which very clearly seems to indicate that there has to really be careful consideration, and there has to be an opportunity for the defense counsel to really be heard. And if that doesn't happen, then you cannot order this trial, the mistrial, under manifest necessity, and therefore the mistrial would be inappropriate, and therefore double jeopardy would attach. Well, in this case, if this is all you had, Picard versus Commonwealth and Commonwealth versus Stewart, if you had these two cases to rely on and to determine whether in this situation, in Karen Reed's case, there was a full opportunity for the defense to be heard, and whether there was careful consideration or meaningful consideration of other alternatives, then it would be a simple ruling that didn't happen here. That absolutely did not happen here. Now, again, this is only if you get past the fact that they were silent and didn't make an objection. Okay, so that seems pretty clear from the Supreme Court. Okay, so if you get past the argument, if you can argue that there was really no opportunity for the defense to make an objection here because the judge went so fast from that note to declaring a mistrial and then dismissing the jury, and then you get into the other prong of manifest necessity, well, then it's really, really looking good for the defense. Now, the big problem with this is that we have this one case, and this is the case that's the biggest headache for the defense. And this is the Fuentes case. We spoke about it yesterday. In the Fuentes case, it was essentially almost exactly the same as the Karen Reed case. The jury was hung. They sent a note to the judge. The judge did not alert the defense what the note said. The judge called in the jury, and he read the note. The judge read the note for the first time when the jury was there, when defense counsel was there, read the note, declared a mistrial. It's like exactly the same as Karen Reed. And there was and not only that, but in Fuentes, after the jury was excused, the defense did object. And therefore, you should be thinking, well, okay, no, it's clear that the defense did not have consent here. The defense objected as soon as they could. And was there any sort of meaningful consideration of alternatives? Was there any opportunity for the defense to be fully heard? Certainly not. And yet, the ruling in Fuentes was that double jeopardy did not attach. That was the ruling in Fuentes. And this case, Fuentes, I believe, I have to take a look at this. Fuentes, I believe, is not a Supreme Court case. And I don't take my word. I don't have the exact site here, but I don't believe that it's a Supreme Court case. It's more of a Court of Appeals case. So what is the defense going to do with Fuentes? Fuentes is really troubling to them because when you had Picard and when you had Stewart, everything was great. It was very clear that even you had a case where the judge did give some consideration, but it wasn't meaningful enough. And the judge and the court felt that was not considered manifest necessity. So what's going on with Fuentes? So you could argue, and this is a fair argument, I think, you could argue that Fuentes was wrongly decided. It just absolutely was. It's right and it's contradictory to Stewart and what was the other case? And Picard. So you could argue that. And that's a decent argument. I think it's a decent argument because if you look at the other cases, it's directly opposite. Nevertheless, it's better always to try to distinguish. Always try to distinguish. And then you can say, first of all, Karen Reed's case is distinguishable from Fuentes. And number two is that Fuentes is wrongly decided, which I think it was. And I think, by the way, that if this case, Karen Reed's case, eventually goes up on appeal and they're able to actually, the Supreme Court is actually able to see all of the case law and then see Fuentes, I think there's a good chance that they would overrule Fuentes and say the Fuentes is not accurate. It's not the right, that's not the right law. And really the law should follow Picard and Stewart. That's what it seems to be. Because from all the case law, it seems that in order to have a proper mistrial under manifest necessity, you need those two prongs. There has to be a full opportunity for the counsel to be heard, and there has to be careful consideration for reasonable alternatives to a mistrial. But listen to how the defense distinguishes it, Fuentes. And I don't know if I would have distinguished it the same way. I think I would have done it a little bit differently, but listen how they did it. In only one case cited by the Commonwealth, Fuentes versus Commonwealth, was the defense, as in the present case, afforded no opportunity to be heard before a mistrial was declared. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of a mistrial expressly stated that the jury cannot reach a unanimous verdict as to either of the two indictments. So in Fuentes, the note read that we are hung and we can't reach a decision as to either of the two indictments. Now, in this case, what did the note say? To all charges. So they're going to go back to their original argument that to all charges doesn't mean all three counts. All charges means all of the charges in count 2. Okay, which again is a very big stretch. So first you got to get the judge to actually believe that or fall for that that's what all charges means. And then to also say, now that you've agreed to that, now this is a distinguishing factor between Fuentes and the Karen Reed case. In those circumstances, while the more prudent course would have been to consult with counsel, the record did not show that such consultation would have produced any fruitful alternatives. So what happened in Fuentes essentially is what the court held is that it wouldn't have produced any fruitful alternatives. So what they're saying in Fuentes is that even if we would have given you the opportunity to object, and even if we would have given you the opportunity to make a full record and to explore other alternatives, none of those alternatives would have been fruitful. So who even needs that? So really, you see right away, whether the alternatives are practical or not should have nothing to do with the law that says that you still have to carefully consider them. So all the law in Massachusetts essentially says up until this point that these two requirements have to be done. Number one, there has to be full opportunity for counsel to be heard. Whether you're going to agree with the counsel or not, you still have to give the counsel opportunity to be heard. And Fuentes is essentially saying, well, if we wouldn't have listened to you anyway, so then really we don't have to give you full opportunity to be heard. That's essentially what they're saying. And then also when it comes to the second requirement, that there has to be full meaningful consideration about other alternatives. The Fuentes court is saying, well, that's only if those alternatives would have been something that you would have acted on. But if they weren't really fruitful, or if you're just playing a game with the alternatives, so then you don't even have to consider alternatives, which is literally like directly against all of the case law in Massachusetts. So it seems to me that Fuentes was just wrongly decided. So I don't like their distinction because I don't think it's a great argument to say that the note, when it said all charges, it means count 2. What I think was a little bit better, if you look at the Fuentes opinion, just to be able to distinguish somewhat, is that there the attorney asked that in his motion for that there shouldn't be the motion to dismiss because of double jeopardy, he asked that they should have asked the foreman if there is a reasonable probability that they may get to a verdict, may reach a verdict on some of the charges. That was essentially what it said. That he was asking that the alternative could have been, was there a reasonable probability that maybe the jury could reach a unanimous verdict on one of the indictments, one of the charges? And that's not a great argument. However, in this case, you could have argued, we're not asking for a reasonable probability that there maybe will be a verdict. It sounds like from the Fuentes course, they were hung on both counts. And the attorney just wanted them to ask the foreman, maybe do you think that there's some probability that you'll reach a verdict on one of them? Meaning maybe the voting on one of them is 11-1 and the other one's 6-6. So is there any reasonable probability that maybe on the 11-1 one, you'll reach a verdict? But in the Karen Reed case, they can argue, to distinguish Fuentes, that in this case, we're not asking for them to go back to deliberate. We're asking, do you actually have a verdict on count 1 and count 3? I think that would have been a better way to distinguish Fuentes and the Karen Reed case. Although, again, my feeling is that Fuentes was wrongly decided, and it's an inaccurate statement of the law. So that's my opinion on this. But this is what they argue. And Fuentes is going to be a real problem. And if I was the Commonwealth, I would be screaming Fuentes the entire motion hearing, because that is what the case stands for. So the only thing you're going to tell the judge is you're going to have to overrule Fuentes from the bench. And that's essentially what really has to happen, because there are other cases, like we quoted, Massachusetts Supreme Court cases, which go right against Fuentes. But it's a very hard position to put a judge in. That's what I would do if I was the Commonwealth. I would say, Fuentes, I'm sorry, Judge. It's nice arguments, but Fuentes, is exactly the same as this case. And, there's nothing to do about it. And their distinction is just not good. All right. And then they also talk about the ethical argument that the Commonwealth made against Jackson, that the rules of professional responsibility in Massachusetts say you're not allowed to probe into the actual deliberations of the jury, their thought process and things like that. You're not allowed to talk about that to the jury. And here it seems that occurred. So they try to make some distinctions about that. Oh, it's okay to ask just about the results. We're not asking about the deliberative process. We're not asking about what their mindset was, or what their thought process was. We're not asking about that. We were just asking about the results, which can technically be ethically okay also. But that's essentially what their reply is. And it's that's what we're left with at this point. Now, the only thing that we're left with is a hearing. And now you are in the absolutely best position. You probably know more than the lawyers already who are going to be arguing this case. And now when you're watching this hearing, you'll be able to really see the arguments a lot better for what they are. Maybe even feel from your couch that you should really be that they should be making different types of arguments. And maybe you'd actually be able to make better arguments yourself if you were there. So that's what it's going to come down to. Like I said from the beginning, the chances of this motion being granted are very slim. I think this is more of an issue, which eventually, if it goes up on appeal, I think it'll be interesting to see how the appeal courts and maybe the Supreme Court deals with this issue, and if they reverse Fuentes. All right, well, that's it for now. Thank you all for watching. Please, if you haven't yet, subscribe, like, and we will see you next time.